Accountants can be held liable for violating state and federal security laws. In this section, we're just going to explore the federal laws. There are two primary federal security laws acts, the Securities Act of 1933 and the Securities Exchange Act of 1934. The Securities Act of 1933 requires that before a corporation sells securities to the public, the issuer must register securities. The issuer must file a registration statement with the Securities Exchange Commission. The registration must include audited financial statements. Under Section 11 of the Act, the auditors are liable for any material misstatement or omission in the financial statements that they prepare for the registration statement or for failing to find misstatements or omissions. This is a civil liability. We're going to be talking about criminal liability in the next video. Civil liability, they're paying damages. They're paying damages that are the price paid and the value of the time of the lawsuit or the value of the time sold the stock. And it's who's, a shareholder or an investor is the buyer seller. Those are the folks that can sue the auditor. There is a defense that's incorporated within the law. This allows accountants to raise a defense to avoid that liability. They have to show that they made reasonable investigations of the financial statements and had reasonable grounds to believe that the statements did not contain material omissions or misstatements. We actually call this that they acted with due diligence in their preparations. So that is a defense that they can raise if, in fact, litigation is started under the Securities Act of 1933. The Securities Exchange Act of 1934 requires a company or corporation that is subject to the Securities Exchange Act of 1934 file with the SEC an annual report containing audited financial statements and quarterly reports with unaudited financials. Under Section 18 of this Act, an auditor who makes a false or misleading statement in a required filing is liable to any buyer or seller of stock who has acted in reliance on that statement. Of course, there's a defense built in here. The defense that the accountant has is that they acted in good faith and did not know that the information was misleading. If they can prove that, then they will avoid liability under this section. Another section of the Securities Exchange Act is Section 10b and Rule 10b-5. These are where most of the securities litigation against accountants is brought because it's actually easier for investors to win than under the section we just went over under Section 18. Under Section 18, a plaintiff, someone who brings the lawsuit, must show that he actually relied on the misrepresentation when purchasing the stock, and that's actually pretty hard to show in court and to meet that their reliance on that. Under 10b, however, the court actually assumes that reliance if there is a misstatement and that misstatement was material or it affected the price of stock. If that exists, then the court's going to assume that the person relied on the statement. So under 10b, an auditor is liable for making a misstatement or omission of a material fact and knowingly or recklessly with intent to deceive, manipulate, or defraud. And 3, that the plaintiffs relied on purchasing or selling the security. So under here, if 1 and 2 are met, the court's going to assume reliance, number 3. A couple cases that I want to go over, like what really constitutes this kind of behavior, knowingly reckless with intent to deceive. I mean, those are big things to prove against an accountant. A couple cases. One is a federal case out of New York, our appeals court in New York. It's called the Second Circuit. A Grant Thornton, who was the auditor, that's the auditing firm. They audited Windstar, which was a broadband communications company that provided businesses with wireless internet connection. Winstar was one of, we'll call them GT's, Grant Thornton, GT's largest and most important clients, but only 12% of the company's fees came from auditing. The rest were for consulting projects. Winston asked that the partner in charge of its audit be replaced and also threatened to fire GT. In response, GT assigned 2 auditors who had no experience with telecommunication companies. When Winstar's real revenues fell, it began to report fake ones. For example, it reported that a large percentage of its revenue was from equipment sales to a technology company, which they claimed was a partner of theirs. Equipment sales were not part of Winstar's core business, and there was little documentation that these sales had actually taken place. Winstar also engaged in round-trip transactions in which it overpaid other companies for goods and services, and in return, those companies bought unneeded equipment from Winstar. GT warned of these transactions, that they were wrong, but ultimately they issued a unqualified audit opinion. And a year later, Winstar filed for bankruptcy protection, and all the investors sued GT, the accounting firm. And the question is, was GT liable to Winstar investors? Under this test, the answer is yes. The court said, deliberate illegal behavior, conduct unreasonable that the accounting firm must have known it would have caused harm, or they completely ignored the obvious signs of fraud. That gave rise to this particular test, and they were ultimately liable to those individuals. The other case, real quick, Advanced Battery Techs versus Bagel. Advanced Battery Techs was a Delaware corporation that manufactured lithium batteries in China. It was required to file financial statements with both the United States Securities Exchange Commission and China's Administration of Industry and Commerce. For 4 years, Advanced Battery Tech's filings reported increased revenues and profits. This is the U.S. filings, and at the same time, its filings in China showed significant losses. When these discrepancies became public, the price plummeted. The stock price of Advanced Batteries plummeted. Shareholders sued the auditors, Bagel, because the firm had issued clean audit opinions during that period of time. And the question is, well, are they liable now to the investors? And the court said no, that it wasn't liable here. The court said that the plaintiff must present facts that constitute strong evidence of conscious recklessness, that is, conduct that is highly unreasonable, representing an extreme departure from the standards of ordinary care, and an actual intent to aid in the fraud being perpetuated by the audited company. That's a pretty big standard, right? Mere allegations that the principles, the GAAP principles, were violated and accounting irregularly, the accountings were irregular. The plaintiffs claimed basically that the accounting firm should have reviewed the filings in China as part of their audit. However, the court noted that neither the standards or the principles requires an auditor to review companies' foreign regulatory filings. So that was the investor's hang-up, and nothing else was shown otherwise. So in this scenario, the mere fact that an auditing firm did not look at other filings in other countries, in this particular case in China, that's not going to be a failure on their part. The United States Supreme Court has said for accountant liability under both of the sections that we just went over, the showing must be intentional and reckless. And this has been held, so this is what applies nationwide under these acts. The Supreme Court held you have to show intentional and reckless behavior on the part of the accountant. Under the Exchange Act 10b, auditors are required to tattle on their clients in some instances. Auditors who suspect and certainly know that a client has committed an illegal act must make sure that the board of directors of that company, corporation are notified. So that's the first step. They have to notify the board of directors when they believe that the client has committed an illegal act, or they certainly know. If the board fails to take appropriate action, the auditors must issue an official report to the board. If the board receives a report like this, an official report from the auditors, it must notify the SEC within 1 business day and send a copy of the notice that they sent to the SECA to the auditors. If the auditors don't receive that copy, they on their own must notify the SEC. This really puts auditors in a tough spot because they, on one side, if they don't do what they're supposed to do under 10B, they get the wrath of the Securities Exchange Commission if they don't comply. But on the flip side, if they comply, then what happens? They get an angry client, right? If they do comply. The final point under this section is joint and several liability. We've talked about this before. It arises in this point here again. It's imposed under the Exchange Act regarding liability. Traditionally, if liability was imposed under this act, the Securities Exchange Act, liability was joint and several, meaning a plaintiff could sue any particular defendant or any group for the full amount of damages. So in this context, if a company committed a fraud and then went bankrupt, its accounting firm that might be the one that the defendant goes after or has to go after because they're the only one left standing with any assets or money to pay, even if they've only caused 10% of the damage, let's say, and the corporation did most, they'd be on the hook for the entire amount when they're joint and several liability under this act traditionally. Congress recognized this, and they went in and amended the act to proportionate liability. So now there's limits. So there's limited liability to a defendant based on their proportionate degree of fault. So this kind of relieves the accountants from full responsibility. However, they will be held joint and several liable if they knowingly violate the law. If they've knowingly participated in it, they're going to be on the hook for the whole thing. But if it's only a portion and it's carelessness, they're only going to be liable for the amount of the damage that they caused. And that is something that gets figured out in the court proceeding, whether it's by the judge that decides or a jury that decides.